Good morning and welcome. It is Sunday, August 23rd, 2026, and this is Sunday Funday from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Wow. Why is Ritter so late? I am so sorry, everybody. It was something I couldn't control. I was doing my best. We were all in a state of panic, but here we are. I promised to give you 20 more minutes worth, at least in quality, if not quantity. So thank you all so much for being here. To Lindsay Bay, Southern CJB, Therapist wait a minute. They're all moving so fast. Best Nancy, Roscoe, Lori, you guys are all so fantastic. Thank you so much for being here. If this is your first time here, let me say, first of all, we're usually incredibly prompt. I pride myself in always being on time. If not a minute late, I feel bad about it. And if it's your first time here, welcome. You're going to enjoy it. This is a show where we take your questions that you've left us throughout the week, and we're going to answer them live. But first, let me introduce myself to you new folks. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for about 10 years before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential, where we do our best to give you both sides of the courtroom, both sides of the issues, both sides of the story. And this is a show we do every Sunday, as I said, where we take your questions live. Your questions that you've left us in a voicemail throughout the week, and we're going to answer them live. And we call it Sunday Funday. Stay to the end. We have announcements, some fun stuff coming up I don't want you to miss. But first, I don't care how late it is, we're going to take that deep, cleansing breath. You made it. It's Sunday. It's the end of the week, beginning of the new one, depending on how you look at it. Hit that like button if you haven't already. Subscribe if you haven't already. We're so close to a huge benchmark in subscriptions, and we'd love to have you all with us. Annalie Finch, thank you so much for kicking us off. Says juiced for Sunday Funday. So am I. Should we just jump into this thing? Enough of the chatter. Yeah, let's do it. Who is kicking us off this morning?
Hi, Josh, and all you CC fans around the world. This is Carol from Rongai, Kenya, just outside Nairobi. I was meeting with the East Africa CC group, and we had a couple of questions that are just kind of general questions. First of all, we had a question, and maybe it's a silly one, about the way lawyers tend to address the judge. We've noticed that frequently, in fact, dare I say always, after the judge makes a ruling or something, the lawyers respond, "Thank Your Honor." Shouldn't this be "Thank you, Your Honor"? I guess we're just sticklers for proper English. The second question has to do with the use of the word alleged. The dictionary says that alleged is used to convey that something is claimed to have taken place, although there is no proof. We can understand its use in the case of David Burke, that he is alleged to have murdered Celeste Hernandez because the proof is circumstantial. And we can kind of understand its use in the case of Lindsay Clancy allegedly murdering her kids by reason of insanity, because it's the insanity that is alleged, not the murder. But we're baffled that we keep hearing about Mickey Steins allegedly murdering the judge when we've all seen the video and clearly he did it. Can you shed some light on the use of this word? Thanks for all you do. We here in East Africa are almost always in the Rewatch crew, but we look forward to our gathering to listen to your wisdom every week. Bye.
Carol from Angada Rongai. I just love saying that name. Kenya. Can you believe that, everybody? Hello to everybody, all of our East African watchers, which so far, as far as I can conclude, just includes Carol, but she's recruiting people. She's working really hard at that. Thank you so much for putting you on the map, for kicking us off this morning. And a great question, says Purple Daisy, and I agree. Thank Your Honor. I have not heard that one. If I'm missing it, I'll try to do a better job of catching it, but I haven't heard that one. Usually, maybe they're just saying thanks, Your Honor, or maybe they're just, I don't know, stumbling over what they say, but that is not like some sort of official thing. It would be thank you, Your Honor. But your second question about alleged is a really interesting one. And it goes to something that's at the heart of the American criminal justice system, and that is the presumption of innocence. Everybody is alleged. Mickey Steins is alleged. It's allegations right now. He's not a convicted murderer. In the eyes of the law, he is an alleged to have committed a crime, alleged to have committed murder. And you say to yourself, well, I'm watching it on play out in front of me. in 4K. How can that be an allegation? Well, maybe in our common vernacular and common sense of it, we say, well, to me, that's not an allegation. But in the eyes of the law, it's all alleged until a person is convicted. And from media perspective, when they talk about it, they're very careful. You'll hear to say alleged, the allegations, according to reports, according to the prosecution. And all of this is important because they don't want to get sued, because it is an allegation at that point. Nobody has been convicted of a crime. Same thing, by the way, bringing us to Lindsay Clancy, which is obviously the hot topic of the day. And most of the questions that we're going to talk about today deal with Lindsay Clancy. By the way, the murder is still alleged. She has not pled guilty to the murder. Now, you're saying, well, she's admitting it because she's pleading not guilty by reason of insanity, or not guilty in Massachusetts by lacking some criminal responsibility because of her mental health. But it's still an alleged crime, the murder itself. The prosecution still has to prove the murder in this case. And that's why some of the evidence has come in that you've heard about the medical examiner's reports and how the murders take place. Now, they're important for other reasons, for the defense being mounted in that case, but it's also important because they have to prove that murders took place here. That is not a given. She has not pled guilty to the murder, but not guilty by reason of insanity. She has pled not guilty to all of it. So it's all alleged at this point. Even if her defense is admitting as much, those are still elements that have to be proved by the Commonwealth in that case. So great question. I hope that clears things up as to why we use those kind of that kind of language. And it's important because everybody is presumed innocent until those allegations turn into convictions. All right. Thank you for that. Let's keep it rolling here. I'm going to try to be a little more less wordy to try to move us along and make up a little bit of time. All right. Who do we got next?
Hi, Josh. It's Suzanne from Framingham, Massachusetts, also known as the Commonwealth of Massachusetts. This is the second time I'm calling in. Anyway, my question is about the Lindsay Clancy case. I'm trying to wrap my head around how someone can be found criminally responsible while also suffering from a serious mental illness. You discussed this on Joe Waldman's show and explained how someone can be mentally ill and still be considered criminally responsible. I know there's a distinction under Massachusetts law between mental illness and legal insanity, and apparently there's a pretty fine line between the two. Could you dive a little deeper into that distinction and explain it in a way that might help me understand how Massachusetts law draws that line? Specifically, how can someone be suffering from a mental illness yet still be considered legally responsible for their actions? Thank you, Josh. Love your show.
Well, thank you, Suzanne from Framingham, Massachusetts. Let's put you on the map. Zoom in there on Framingham. Where is it? There it is. I was in Boston last week. I'm going to be going out there again. And I will tell you, I've never been to Boston, never been to Massachusetts. And I thought, oh boy, this will be fun. I get to go to Boston. I'm not in Boston at all. I'm in Plymouth, which is about an hour south of Boston. So I feel like I still haven't seen Boston. I've seen it from the airport coming and going, but still haven't seen it because this case, the trial, is taking place down in Plymouth. Thank you, Suzanne. This question that you're asking really is getting to the heart of the issue. How can somebody be criminally responsible and also mentally ill? And how do I say this? How do I explain this in a way that is easiest to understand? Many people are mentally ill. Let's put it that way. If mental illness alone was the defense, you would have full hospitals and empty prisons. many people suffer from some degree of mental illness. And you could even argue that you would probably have a higher percentage of folks suffering from mental illness who have committed murders than otherwise. Obviously, that can't be the bar. Obviously, that can't be the defense, just any showing of mental illness. So where do we draw the line? How do we create a fair line to say mental illness should play a role, but it shouldn't be a flat out bar towards criminal responsibility? Well, the way that most jurisdictions handle it, some jurisdictions, by the way, don't have any kind of a mental illness defense at all. In an insanity defense is kind of the shorthand way of referring to it at all. And some have very robust defenses. Massachusetts happens to have one of the most favorable defenses to defendants bringing this type of defense. And we'll get more into the reasons for that later. But we've said, okay, and when I say we mean the criminal justice system has said, okay, well, where should the line be drawn? At which point you should not be criminally responsible for your actions. That line should probably be at its most basic form of mens rea, right? You've got an actus reus and a mens rea. You did a thing, and you also had something going through your head at the time that you did it. The mens rea says, if you can not appreciate that even what you were doing was wrong because of your mental illness, you are so unconnected from reality that you can't even appreciate that what you were doing was wrong at its most basic form, that is too far. That is too much to hold that type of a person responsible for their actions. And that is where the line is drawn. And the same applies here in Massachusetts. That is, it's a two-pronged test. You have to have both a mental illness and not appreciate the wrongfulness of your actions, or not be able to control your actions because of some mental defect or illness. And that makes a lot of sense when you think about it. We do not want to hold people criminally responsible who simply couldn't appreciate what they were doing or couldn't control what they were doing because of some sort of mental illness. So yeah, you can be mentally ill and be criminally responsible. You can, to get it more down to the weeds of the Lindsay Clancy case, you can be in the depths of psychosis and still understand that murder is wrong. You can be suffering from auditory hallucinations and still understand that murder was wrong. We're talking a lot about psychosis, and we're talking a lot about auditory hallucinations when it comes to Lindsay Clancy, because those help the jurors understand just what level, to what degree she was suffering from mental illness. But that is not the standard. Psychosis does not equal insanity. Auditory hallucinations do not equal insanity. They can be circumstantial evidence of that, but they are not alone a full stop explanation or definition of insanity. So that's where the prosecution is going to have to do some heavy lifting here, because I think the defense has done a remarkable job of showing that, yes, she was suffering tremendously from mental illness. She was likely in the throes of some sort of psychotic break. She was having auditory hallucinations, according to her own experts. But if the prosecution can prove that in spite of all of that, she still knew murder was wrong, then she should be held criminally responsible. And that's why the prosecution is leaning so heavily into her actions before and after. The planning, how long does it take for him to go run those errands, the actual commission of the murders themselves. How long did that take? How did she have to separate the children? All of these things, the prosecution is arguing, is circumstantial evidence that she was in a position to understand the wrongfulness of her actions. I hope that makes sense. I know a lot of people are struggling with this. A lot of people are saying, well, she had psychosis, but that's not the question. Yes, she may have had psychosis, but can you have psychosis and still appreciate the wrongfulness of your actions? And all of the experts have, in fact, admitted to that. But great question, Suzanne from Framingham. We appreciate you asking. All right. Let's keep it going here. But first, let me thank Mandola Jane so kindly for the support. Coffee for the mods. I have a feeling you may need it. Thanks for your Trojan work to keep the chat sane. Mandy, I applaud that 1,000 times over. Our mods have been working overtime on this trial. It has been a very busy one, a very busy chat, and we appreciate you all. Here's one of them. Shy Gal says, clearly Corey Richards was not well in the brain. Clearly. But again, not the standard. Not well in the brain would allow for a lot of people to enjoy that defense. Jules, thank you, says, move aside coffee, starting up a separate massages for the mods fund for all the wonderful Lindsay Clancy trial moderating. Oh, I like that. Spa day for the mods is coming up quick, I imagine. All right, let's keep it rolling here. Here we go.
Hi, Josh. It's Maddie from Wichita, Kansas. I'm a first-time caller. I have kind of a double question. So, if Kohberger is able to repeal his guilty claim, if he does get a new trial, would that mean if he goes to trial, loses, whatever happens, that then he no longer has any more appeals to exhaust? Or does the family have to put up with X number of appeals until he exhausts all of that? Same kind of goes for Lacey. If she is convicted and she spends time in either prison or a mental facility, and she's found, guilty, what does the appeal process look like for her?
Maddie from Wichita, Kansas, a first-time caller. I love it. Let's put you on the map. Looks like a first-time caller from Wichita as well. Thank you so much for calling in, Maddie. All right. And a great question, too. Bryan Kohberger, interestingly. Yes, there's other cases in the news at this same time. Bryan Kohberger, Maddie wants to know, now that he is making this motion, if he gets a new trial, does that mean he's exhausted his appeals? And the answer is no, because he's not appealing anything. This is not an appeal. He is attempting to withdraw his guilty plea. That's not an appeal. You remember when he entered his guilty plea, he waived his rights to appeal. And he did, and he still has not appealed. But what he didn't waive his right to, and what you cannot waive your right to, is the ability to withdraw your plea. Why is that? Because he is making the argument that his plea was illegal to begin with, because he wasn't properly advised. And that is the one thing that remains. And that makes sense, too, when you think about it. We don't want people who take a guilty plea, get into prison, and then realize that perhaps their attorney didn't share everything with them, or their attorney misled them about the consequences of their appeal, or their attorney misled them about the strength of whatever defenses they may have had. We don't want that to be true. So your ability to withdraw your plea is something that survives, even if you enter a guilty plea and even if you waive your right to appeal. He's not appealing anything. He is attempting to withdraw his guilty plea. Now, I do not think he will be successful on that. If he is successful on that, he will go to trial. And if he is convicted, he will still have all of his rights to appeal, because the guilty plea is off. All bets are off. The guilty plea is off. The agreement to not pursue the death penalty is off. And his agreement to not pursue any appeals is off. It's fair game on everything. Lindsay Clancy is in an entirely different position. If she is found not guilty by reason of insanity, and I'm just using that short term, don't come at me. I know that Massachusetts doesn't call it insanity, but if she is found not guilty by reason of insanity, she's not convicted. There is no appeals. There's nothing for her to appeal. There's no conviction. She is not guilty. She won't have a felony record. She will not be a convicted felon. She is a person who has been acquitted of a crime by reason of insanity. she will go off to a mental health institution. That could last for decades. That could last for years. That as soon as she is let out of that, she is a free person, untied to the criminal justice system in any kind of way. If she goes to prison, if she's convicted of this, not an insanity, but the jurors say that, no, we believe you are criminally responsible, and she is convicted, then she maintains all rights to appeal that any convicted felon would have. So that's the way it's going to work for her. I think that's one thing that's important to understand, is not guilty by reason of insanity is not guilty. That is a person who has no connection to the criminal justice system, just as much as a person who was found flat out not guilty. The only difference being she would be civilly committed to go to a mental health institution. Great question, Maddie. And thank you so much for being a part of the crew and now being a part of the conversation. We appreciate that. All right. Let's keep it rolling here. PTA Mama RN, thank you so much for the super sticker. That's very kind of you. And thank you again for the super sticker. Again, very kind of you. And to the gobbledygook of the CW. Dr. Mack and the prosecution lost me when she said Lindsay Clancy is currently an OLZ, a heavy-hitting antipsychotic. Oh, currently on OLZ, a heavy-hitting antipsychotic, approximately 3 years later, and he glossed over it like it was a tic-tac. Yes, I know that the defense has made, and rightfully so, pointed out to jurors how his evaluation of her was not done in the same proximity of time as the evaluation done by the defense witness. And that's something that absolutely is open for criticism, and rightfully so on cross-examination. Thank you for that. All right. Did I lose my place? I don't think I did. I think I'm doing all right. Hold on. Here we go. Hold on. This is the part where I have to press the buttons. And so without Kaylin doing it, it's going to take a little bit longer. Here we go.
Hi, Joshua. This is Amanda from Texas. I'm a newer listener, but I love your coverage of the Lindsay Clancy case. What I'd like to see you cover is the newest theory that's emerging, that somehow her husband, Patrick, was involved in either fumbling her meds or causing this to happen. I'd love to get some insight on that theory and where it stems from.
Amanda from Texas, let's put you on the map. And I don't know where in Texas, so we're just going to put you square in the middle of Texas. Thank you so much for calling in. Thank you for asking the question. Let me just say this about Patrick. There's a lot of really far-fetched and, in my view, unfair theories and conspiracies surrounding Patrick that are going around online. Those, I cannot say with a more full chest, are flat out false. That's not, I think, what Amanda is asking at all. I know there is stuff like that going around. What Amanda is asking, I believe, is a little more nuanced. There are people who feel like somehow Patrick should hold some responsibility for what happened to the children and what happened to Lindsay by either not being involved enough or not, or the idea that he left her with the children that day. And let me say this clearly as well. In my view, there is no mechanism by which Patrick Clancy should be held responsible for what took place on this day. I have seen people, legal commentators online, who say, yeah, well, maybe there's some sort of avenue for criminal neglect here of the children. To me, that is, this is my opinion, and so I'm going to share it with you freely. To me, that is preposterous. What jury are you going to stand in front of and say, let's hold this man criminally responsible for this horrific nightmare that nobody really saw coming? That was a woman who had a complete mental break and did the unthinkable. And we're going to come back and say that somehow he shares some responsibility in that? No jury on earth is going to buy that. No prosecutor on earth is going to pursue that. Given the facts of this case, that to me is preposterous. If you had a man who you had evidence of him somehow, I don't know, refusing her to allow to take her medications, or a person who was physically or emotionally abusing her behind the scenes, somehow played a role in her continuing mental health decline, maybe. But I don't see any of that. I see a man who was struggling with his wife, dealing with some really heavy-duty problems. In retrospect, could we say, well, he could have done more? Maybe, sure. But far be it for me to judge what it was like in that man's shoes in that household. It sounds to me like he was earnestly trying to support her and get her help. And did that, could there have been a way for him to prevent all of this? I have no idea. I have no idea. She was seeing specialists. Many of them missed it. She was speaking to her family, her mother-in-law. Many of them missed it. All of them said, interestingly, all of them said they were worried about her, but no one was trying to get her committed. No one felt that this nightmare was on the horizon. And to say that somehow he should hold responsibility because he left her with the kids that day on a day that they were, making snowmen, and he said it was a really good day? Please. Like, has this man not been through enough? There is no one on earth I think would trade places with Patrick Clancy. He goes and runs some errands. He comes home and he finds, first off, his wife outside of the home, paralyzed, wrist slashed, neck slashed, on the verge of death. She says she's just attempted to take her own life. That is so traumatic and horrific alone. And then to go inside the home and find something, he will never be the same, having found what he found. Never be the same. The fact that this man is able to get up in the morning and put one foot in front of the other is remarkable to me. And now, after all of this, and he's supporting his wife, by the way, sitting there and saying, I didn't marry a monster. I married a woman who got very sick. I think that's incredibly admirable of him, having gone through what he's gone through. And now he's going to get trashed online? It's beyond for me. I just don't get it. I don't understand it. I don't understand why all the attention and vitriol is being turned toward this man. Lindsay Clancy, I think, was failed in many ways. I think there were professionals who missed it. I think there was a culture of pills that missed it. But the last person I think we should be concerned about pointing fingers at is Patrick Clancy. I feel that these conversations are really unfortunate and take our eyes off of the more important issues at play here. Those are my personal feelings on the whole thing, but I appreciate you, Amanda, for giving us an opportunity to explore that. And I thank you so much for calling in. HMS Gen X lady says, do you think defense should have asked for a mistrial over religious comments to preserve it in the record for possible appeal? You know what? Yeah, I think they probably should have. He might have, by the way, because you remember they went to sidebar immediately after that question was asked. This is HMS is referring to the prosecution asking the mother-in-law, was she religious? And did she know that, therefore she must have known that murder is a mortal sin. You guys all remember this moment. It was something that many people reacted to. The judge reacted to it. The judge said, counsel, step up to the sidebar here. I think he probably preserved it then, but he didn't ask for a mistrial. I think he probably preserved the idea that this created some sort of prejudice and that he objects to it, but he's not going to ask for a mistrial because he doesn't want it granted, because I think he knows this trial is going about as well for him as it possibly could. He probably could have asked for a mistrial. He may have gotten it. I don't think so. I think the reason it would have been denied is that there is a logical reason to explore that. Again, we're talking about wrongfulness and whether or not Lindsay Clancy appreciated the wrongfulness of her actions. That can include a religious understanding of it's wrong. I think it was a very blunt and inappropriate way of asking it. But I do not think it was enough to rise to the level for a mistrial. It just looked really bad. But I think that he did not ask for a mistrial because he didn't want one. And Parter, thanks you so much for supporting the mods with coffees. That's very kind of you. And Just Jules doing my favorite thing, gifting memberships. Thank you so much for that. All right, let's keep it rolling here. A lot of questions for us to get through.
Hi, Josh, and everyone at Courtroom Confidential. My name is Lizanne, and I'm an avid listener since the spring of 2025, and this is my very first time calling. I'm from Sudbury, Ontario, Canada. I love your show along with Joel's STS show. I'm a retired nurse, and I've been addicted to watching trials and your recaps and interpretations since finding you all on YouTube. And I also love Prof. Joe's input as well. I have to say, my favorite prosecutor to watch has been Georgia Kappelman. She's amazing. Love to watch her. Still patiently waiting for Wendy's arrest. I'm learning so much about your judicial system and courtroom etiquette and terms, so thank you for what you do, all of you. I've been glued to my television watching the Lindsay Clancy trial. My two-part question is this. Kevin Reddington might be a great lawyer, but I find him to be kind of a bully in the courtroom and even disrespectful at times. And in this, I mean, like in his mannerisms and the way he carries himself and sits on his chair and postures himself. I don't know, it's just kind of my opinion. And why would the judge allow that? Sometimes he can be pretty rough on the witnesses, and I even noticed a few times he didn't stand up when the whole courtroom was supposed to stand up. Anyway, second question is, have you seen during this trial any quotation mistakes, for lack of a better word, that would be useful for Lindsay Clancy in an appellate court? There's been so many sidebars and breaks in this trial, and I feel as though there could be many things that could be revisited on appeal. It feels a little bit chaotic, to be honest. Lastly, I just want to say that I started out this trial thinking she's guilty as sin, lock her up. But watching the trial play out, I'm changing my mind on the daily. I'm back and forth. There is definitely reasonable doubt, in my opinion. I can't imagine how difficult this is going to be for a jury. On that note, Joel stated yesterday on STS, I'm pretty sure it was there, that it would dwindle down to a jury of 6 that would deliberate. Then later he said something similar.
Oh, Lizanne from Sunbury, Ontario, Canada. Thank you so much for being a first-time caller, for being a part of the crew, and now being a part of the conversation. We appreciate that. Love the first-time callers. Let me get to that last bit about the jury. There are, I don't know what Joel was talking about. I love Joel, but I don't know if he was confused or misspoke or what. But there are 18 jurors sitting inside of the courtroom, 12 women, 6 men. The way it works in Massachusetts is that they don't know who are the alternates at this point. Many jurisdictions, you pick your 12 sitting jurors, deliberating jurors, and then you have your alternates picked afterwards, and they know they're alternates. Now, everybody's supposed to pay attention because you don't know when one of those jurors might be dismissed and an alternate has to step in. So everybody should be paying attention. But in Massachusetts, the way it works is they don't tell them who's deliberating, which I kind of like, because then they all think I might be deliberating on this thing. And I feel like it might encourage everybody to really pay close attention. And what will happen afterwards is randomly 12 out of that 18 will be chosen to go deliberate. And the remaining 6 will be the alternates who will stand by in case something happens during deliberations and one of those jurors has to be excused. And interestingly, in Massachusetts, too, the judge picks the foreperson. I don't know why that's funny to me, but the judge will pick whoever is going to be the foreperson. All right, let's get into your question about appellate issues that have come up. I haven't seen any, to be honest with you. I think this judge is doing a great job. I think he has really. This is a high-profile, emotionally intense case, a lot of moving parts, and I think he's handled it very well. I'm a big fan of this judge. I think he's doing an excellent job, and I have not seen him make a decision yet that I've thought, oh, that's clearly going to come up on appeal. Doesn't mean that there aren't going to be issues on appeal. That's what appellate attorneys do, is find issues. I just can't see one that is so blaring to me in this case. Now, to your opinion on Reddington. I love this. I love this because I think this is a great example of how it's important to not enter an echo chamber. I have seen people online who think that Reddington walks on water, and they think he's the greatest thing they have seen inside of a courtroom, and they think the man can do no wrong. And Lizanne, I'm not trying to put words in your mouth, but Lizanne says, I think that sometimes he appears to be a bully, or sometimes there's something about the way that he carries himself that I don't entirely agree with. And I'm not going to go either way on this whole thing. I just think that that's such a great example of you don't know how the jurors feel about it. Don't get high on your own supply. Don't get so convinced of your own position on this thing. We don't know how the jurors are viewing this stuff. I've seen people who watched, and in particular, I think what you might be alluding to is the cross-examination of Dr. Tufts. That was a real contentious examination. He really went after that doctor. And I saw people online who thought it was remarkable. And he didn't go after her hard enough. And he should have really grilled her. And boy, did he get her. And then I saw other people who said, I think he was a little too harsh. I think he was a little too mean. I personally thought she was responding to him in a very mild-mannered way. And that I thought he was leaning on her heavily. But at the same time, that really depends on how the jury is viewing it. If the jury is viewing it like she needed to hear all that, Dr. Tufts, then they're cheering him. But if they're viewing it perhaps how Lizanne and others are viewing it, they might have been turned off by some of that more aggressive points on cross-examination. He is quick. He's very quick, and he's very smart. And he does have this ability to kind of have a quick comeback that might be a little snarky at points. Now, if you're a juror who feels that witness deserves it, then like I said, you're applauding it. But if you're a juror who doesn't, then it might be landing in a way that is not all that effective for Reddington. Personally, I think he's a very good lawyer. Very good. He's obviously very skilled. I think he's very smart. I think he has a folksiness about him, which works really well. But yeah, I just loved this question because I think it's a really good opportunity for us all to go, hey, wait a minute. Maybe not everybody is feeling the way I feel about the way this is playing out. And more importantly, maybe the jurors are not feeling the same way. And maybe even all the jurors aren't feeling the same way about it. That's why I think this deliberation is going to be so incredibly difficult. If we all are having difficulty agreeing on almost anything in this case, think about what they're going to be going through. Great question, Lizanne. I appreciate you asking. All right. Where are we off to next here? Hold on. Everybody calm down. I'm going to find it. Here we go.
Hey, Josh, it's Nell from Michigan. Not sure if this is really a question so much as something that's been bothering me following the Clancy trial and all the discussion surrounding it. I'm relatively new to this LawTube world. Haven't even been a part of the CC fam here for a year yet, but I really dove into the deep end. So listening to you and a few other channels like this has been where most of my conversations about these trials happen. For whatever reason, the Clancy trial has popped off outside this bubble, most notably on social media with people and groups that normally just talk about pop culture type topics. The thing is that the conversations there are very different than the ones we're having here. Instead of discussing and even disagreeing about the very tough issues at play here, it seems like the general public has completely lost the plot. I'm seeing games of whodunit, complete with digging up dirt on the family and arguing about things that aren't even on trial. I find myself wanting to say something, but wouldn't even know where to begin. And I really hate conflict, so I don't even want to get into it. But it really bothers me. I mean, have you seen any of this? Is it more so than other trials? And most importantly, it's one thing if we can watch and analyze a trial, but what does it say about our society as a whole if the general public is interested, but can't be bothered to actually pay attention to what we're even talking about?
Nell from Michigan, you put that so well. Let's put you on the map, first of all. I agree, Nell. It is hard to remember the last time a trial had a cultural moment like this. And a moment there where there was a lot of conspiracy, a lot of kind of people with hot takes that I think are lacking the sensitivity and nuance that this case deserves. I mean, we're not talking about a victimless crime here. We're talking about 3 dead children. Can we please save the crazy conspiracies for a case that doesn't involve 3 dead children? I agree with you. I don't understand it. I think part of it is interesting as far as why is this case having such a cultural moment. We've been following this case since it happened. I remember talking about this case and reporting on the pre-trials that were coming up. And we were talking about, they're going to mount an insanity defense and all of that stuff. And I never saw it coming this. Never in a million years did I think you would see a crowd of people outside of this courthouse like this. But every major news network is picking it up. I go through my social media, as I'm sure you guys are, and everybody's talking about it. From legal commentators to news folks to sports people to people who have never talked about a criminal case in their lives, and they're all taking the opportunity to weigh in on Lindsay Clancy. And it really does seem to have had a snowball effect too. Some of that I think can just get explained by clicks. People are looking for clicks. They're looking for attention. And this happens to be a case that's getting a lot of attention. But I think at the core of it, there's some interesting things at play here. One, you're talking about women's mental health, right? And that is something that I think is important to a lot of people. You're also talking about a woman who was failed, I think, by the medical healthcare system and the mental health care system. And that's important to a lot of people. And that should be important. And it should be a conversation starter. Then you've got 3 dead children. which is important to a lot of people. And so people are very passionate about that as well. And I think it's kind of a perfect storm of all of these things coming together. But there is this unfortunate dark side to all of it. I've seen these people online, these influencers who you can tell know nothing about the case and weigh in with their conspiracy theory that they have on the whole thing. And some of it is really ugly to me. It really is very ugly. Like I said, you want to have conspiracy theories about Blake Lively and what's his name? I'm going to mess it up. And shoot, Blake Lively and the other guy, Baldoni. Yeah. Go ahead. Nobody got hurt there. Nobody's dead at the end of that. But you want to have these really horrific conspiracy theories about 3 dead kids, and a lot of them surrounding the father of those 3 dead kids. He lost his children and his wife on the same day. His wife that he had stood by, had 3 kids with, attempts to take her own life and is likely going off either to prison or a mental institution for the rest of her life. And then he lost his 3 babies. You know, we've been putting up pictures of the family and we've been blurring the faces of the children. And a lot of people have asked, why are we doing that? Because their faces have been shown on other outlets. I'll tell you why we're doing it. Patrick Clancy had talked about asking for that. To have a little bit of respect for the loss. This is not a game. This is not a TV show. This is not, if you want to get all hot and bothered about Love Island, go for it. But you want to start acting like these people aren't real people who are living through incredible tragedies. I got no patience for it. There was a request to have a little bit of respect and not show the faces of the children. And that's a small thing, I think, to ask of us. And so that's why we've done it. But great question, Nell. I don't have a clean answer for you. I don't have a clean answer. What I have is a lot of confusion as to why it's turned into what it's turned into. And a lot of it makes me very sad. But great question. All right. Enough with that, Ritter. Keep it moving. People don't want to hear you pontificate ad nauseum. They want to hear you answer questions. Here we go. Hold on. All right. We did that one. Now we're on to this one. Here we go.
Hi, Josh. This is Jen from Columbus, Ohio. I just have something that's really been bothering me about the Lindsay Clancy case is I feel like this is a really slippery slope. So regardless of all the controversy, was she psychotic? Was she not psychotic? It seems like it's so emotionally evolved at this point that we're losing fact of the fact she killed 3 kids. And it appears that she planned things. She knew what she was doing. Personally, in my opinion, I think she knew what she was doing, and she had plenty of time and opportunity to get help. But that said, the slippery slope is if she's let off for killing 3 people, anyone that kills somebody likely has some type of mental illness. Where does it stop from there? It seems like this is a really slippery slope where now anyone's just going to be able to make a claim and go for that insanity plea. And it just seems like we need to hold her accountable. And it's just really upsetting, but just would like to hear your thoughts. Thank you.
Jen from Columbus, Ohio. Let's put you on the map. Thank you so much for asking the question. I kind of touched on this before, but you put it really well, Jen. You're right. The standard is not just mental illness. I've heard other people say things like, well, nobody in their right mind would do this. And that drives me at the wall. That's not the standard. Nobody in their right mind would commit pretty much any crime. I've been dealing 20 years of my career, more, I forget how old I am, with people who are not in their right mind. Like, there is an argument to be made that anybody who commits any kind of crime of violence was not in their right mind at the time. That is just not the question here. If you want to say, well, Lindsay Clancy didn't live with any kind of violence in her life before, and there's no other explanation as to why she would do something so horrific, but that she had a mental break, that's getting a little bit closer to the question, I think. And I think that's definitely starting to get us an understanding of the defense perspective on this whole thing. But again, the standard is not mentally ill, psychosis, auditory hallucinations, bipolar, whatever diagnosis you want to throw out there. The law in Massachusetts doesn't include any single one of those words. This is not a medical verdict. It is a legal one. And the law is concerned with the mens rea. What was going through your mind? And if what was going through your mind was simply an inability to appreciate right from wrong, that's where criminal responsibility ends. But you're right, Jen, not to just kind of get into the same points that I made earlier. You're right. Our hospitals would be full and our prisons would be empty if that's the way it works, if it was just mental illness. She was mentally ill. I fully, if the question was Lindsay Clancy mentally ill beyond a reasonable doubt, I'm fully on board with that verdict. But it's far more nuanced than that and far more difficult. And that's why I think jurors are really going to struggle with this. When I will eat the shirt I'm wearing if they come back with this thing with a quick verdict. I just do not think. Just look at the chat, talk to your friends, look online, and you can see how difficult this case is. And I just don't think that these 12 people are going to get together and say, we've got an answer all that quickly. Now that I put it out into the universe, it'll probably take them a couple of hours, but I just would be absolutely floored by that. Thank you so much, Jen, for that question. Appreciate you. And let me thank the Crafty RN. Says, please be kind and respectful in the comments. This is an emotionally charged topic for all of us. Thank you for that, Crafty RN. I realize emotions, tensions, opinions are running really hot and high on this. And I really appreciate everybody doing their best to be respectful of other people's opinions. I'm trying to do my best to not turn this hyperbolic and turn this into something where I get a bunch of people worked up. I'm really doing my best to be as objective about this thing as possible. And I appreciate you all working together to do that as well. We want this to be a very kind place to discuss this. Jerry Michael, thank you for the super chat, says Carmelo Anthony retrial denied. So where does he go from here? Great question. Yes, the judge actually ruled yesterday on a Saturday on this. He denied his motion for a retrial. He was basing that upon arguments like the lack of cameras in the courtroom, the idea that there was this quote unquote gentleman's agreement between the attorneys that they felt was mishandled when it came time for him to testify. I'll be honest with you, this is not a surprising decision here. I think it's the right decision. What will happen now is he gets to appeal. A motion for a retrial is kind of your first step along the way, and it's done at the trial court level. So he has asked the trial court to give him a new trial. That was denied. Now he'll go one level up to the appellate court and probably make many of the same arguments plus some others to try to get an appeal that may include a remedy of a new trial, or it may include a remedy of an overturning of a conviction, or whatever the appellate court feels is appropriate, or it may just be flat out denied by the appellate courts as well. But that's the next step for him. But that probably won't be for several months to years down the line. Thank you for that, Jerry Michael, for bringing up that case. And I understand that what is it called? What is our bot called? Nightbot is broken today. Nightbot took Sunday off. Who's going to have a chat with Nightbot about this? This is unacceptable behavior. Kaylin's going to chat with Nightbot. That is not good news for Nightbot. Because of that, it's now on me and everybody in the chat to remind you to please subscribe, Please share this with anybody you feel might enjoy it. Please like this episode if you get a chance. All these things, by the way, completely free to do. Completely free. The government won't know about it. And we appreciate all the support that you guys give us, because we make it our goal, our mission, to never be live and allow YouTube to interrupt it for you guys. And that's what we have kind of dedicated ourselves to do. And that's why we're so appreciative of all your support otherwise. All right. Where am I at here? A lot of questions, so it's difficult for me to get through all these. Here we go.
Hi, Josh. It is Kara in Colorado Springs. You also know me as the bipolar astrophotographer. I've been wondering, why are the only two options for Lindsay Clancy either guilty of murder or not guilty by reason of insanity? It seems like the better fit for her is guilty by reason of insanity, and the conviction should be life in a commitment mental hospital. I'm assuming that's not an option because that doesn't exist, or that there's not a law that allows for that to exist. Do you think that there should be? The biggest struggle with this case for me are the two contrasted convictions within the jury's reach. I think we're all learning that mental illness falls into a very gray area, and there likely aren't any better options. But for people like Lindsay, there should be. I'm not sure how any juror is supposed to believe what either side presents, prosecution or defense, regarding Lindsay's mindset in the moments of the murders. I'm not convinced that Lindsay even knows or ever did. Anyway, just wondering what you think about that. Thanks for answering my question. Bye.
Kara from Colorado Springs, Colorado. Let's put you on the map. So good to hear from you. Kara, you want to sit on this jury? Does that sound fun? These poor folks, they got a summons. They showed up to jury duty. They're doing their civil service. They're answering their questions as earnestly and honestly as they can. And they get selected for a trial that's probably one of the most difficult trials I can think of in recent memory. You know, it's one thing when you're sitting on the Alec Murdaugh case, right? And it's a circumstantial evidence case, and there's some evidence in support of his conviction and maybe some evidence that works against it, and you're sitting back there trying to balance all these things. It's another thing when that question is not present at all. Lindsay Clancy, through her attorneys, is not making an argument that she didn't do this. And it comes down to a far more nuanced and difficult question, which Kara outlines. What was happening in her head? I don't know. I don't know what was happening in her head. I know what she did. Ask me what she did, and I'll give you an answer. Ask me what was going through her head, and I'm going to really struggle with that. And that's what these jurors are going through. Kara also brings up a really interesting legal concept. So the choices here, okay, not to get too wild on this, but there is a choice of not guilty flat out. If the prosecution were not to somehow prove some element of murder, there is an option for not guilty. But really what we're looking at here is guilty or not guilty by lack of criminal responsibility, or what I'm going to call not guilty by reason of insanity. But Kara says, well, what about like another option where we're saying you're guilty, but we believe that mental health played a significant role in that? Kara calls it guilty by reason of insanity. Well, there is this option in some states. It's called guilty but mentally ill. 13 different states have some variation of this. What happens is that person is guilty. They are convicted of a crime. They do go to prison, but there is this acknowledgement of the idea that the crime was committed while a person was severely mentally ill, but not to the extent that they couldn't appreciate the wrongfulness of their actions. Now, what happens to that person? They go off to prison. They get mental health care, but they do serve their time in prison. And I think it's important to understand too, if Lindsay Clancy is found guilty here, she will go to prison, but that doesn't mean she won't receive mental health care. First of all, she's not going to be in some sort of general population women's prison. she's going to go to some sort of hospital ward, some sort of medical ward in that prison. She's paralyzed. She needs extra care. She needs, help getting in and out of showers and beds and everything else. She's going to have special attention for that alone. Then she will have special attention for her mental health issues as well. There are, we just discussed this many times before, many people in prison with varying degrees of mental health issues who are receiving care. They're receiving medications. They speak to psychiatrists. They have therapy sessions. She will receive that if she goes off to prison. Will it be as good or to the same extent as if she went to a hospital? Probably not. I don't have the answer on that because I don't know how the prisons and hospitals are in Massachusetts, but I would not quarrel with the idea that it probably won't be to the same degree. But it's important to understand, too, that if she goes to prison, she's not going to be abandoned completely and just left to kind of figure it out for herself if she were to go off to prison. But yeah, there are some states, and maybe we should think more seriously about that option of guilty but mentally ill. Thank you so much, Kara, for asking that question. All right, let's keep it rolling here.
Hey Josh, it is Kim from Johannesburg, South Africa. I discovered your show because of my fascination with the Lindsay Clancy case. I have a question with regards to her insanity defense. As I understand it, Massachusetts is unique in more than one way. Not only does the prosecution have to disprove her insanity, but it's also one of the only states in the US that has the two-door insanity defense. So insanity in some of the other states would have to prove that they didn't know it was wrong when they were committing the crime. But in Massachusetts, there's the second volition option of, even if she knew it was wrong and she had no ability to stop herself due to her psychotic break, then her insanity defense also stands in the state of Massachusetts. Please, can you talk to that on the show? Because I've only actually heard you speak about the first door, which is, or the first option, which is pretty much widely available through the United States, except for, I think, 4 states which don't have that as an option at all.
Yes. Thank you so much. Kim from Johannesburg, South Africa. Let's put you on the map. So great to have somebody from South Africa joining us. So you are not the first person to say, Josh, there's this other prong. There's a volitional prong. And if I've not done a good job of acknowledging that, then my bad. Yes, in Massachusetts, there are 2 things that the prosecution must prove. We talked about this before. Is it an and or? Well, it really depends on the perspective. The burden rests with the prosecution, so I think we should look at it from the prosecution perspective. The prosecution has to prove that, well, here's how the prosecution can handle it. 1, they can prove she didn't have a mental illness. That, I think, is clearly established. But having established that she has a mental illness, then they have to prove that, 1, even with that mental illness, she could either cognitively understand the wrongfulness of her actions, and they have to prove what's called the volitional prong, that she could conform her conduct to the requirements of the law. Now, I haven't not talked about that volitional aspect a whole bunch because I can't really see a way in which that is supported by the evidence in this case. When we're talking about volitional, we're talking about a person who has demonstrated that they didn't have the ability to control themselves. That's not, by the way, a person who feels so compelled by voices. That's not what we're talking about. We're talking about the ability to conform your conduct. There are cases that talk about this. One was a person who was dealing with epileptic seizures because they had a injury to their temporal lobe. Another person who had was dealing with a alcohol-induced organic brain syndrome, which was affecting their ability to control their actions. This is the type of stuff that we're talking about. I don't see elements of that present in this case. I see, in fact, much evidence of a person who was able to control their actions. She separated the children, had exercise bands around their neck, answered a phone call, returned a phone call, slit her wrist, slit her neck, jumped out of a window. None of this to me demonstrates somebody who wasn't able to control their actions or conform their actions to the requirements of the law. Now, that all being said, her experts have said that she was both. They're covering all bases. They're saying that she was both unable to appreciate cognitively the wrongfulness of her actions and also volitionally unable to conform her conduct to the requirements of the law. And they haven't really explained how, but they're just saying she was suffering from this psychosis that just caused her to not even be able to control her own actions. I don't see it, so I haven't leaned into it much. Not to say I don't understand it or I don't think it's important. I just don't think that is where the defense and prosecution are spending much of their time in this case. But great question, Kim, for bringing that up. And I hope that I answered all of your question. I think I did. All right, let's keep it rolling here. Where are we at? Hold on. You guys were really into
Good
this
morning,
case
good
this
afternoon,
week.
good evening, wherever you are. Josh, Tiff, Kaylin, Mods, and all the lovely CC crew. This is Misbehaving from Sandy Acre, near Nottingham. So I heard that the judge in Duane Keffe D Davis, I hope I said that right, trial says the book he had ghostwritten called Compton Street Legend can be used as evidence by the prosecution, which on a Bruce Rivers notes is the biggest self-snitching there is. So my question is, have you ever been involved in a case on either side, whether prosecution or defense, where the self-snitching has been so outrageous? Or do you know of anyone involved in such a high-profile case where, again, self-snitching is just off the charts? Would love to hear would love to hear the details. Thank you in advance. Stay safe, everyone. Bye-bye.
Misbehaving from San Diego, England. Thank you so much for calling in. Let's put you on the map. There you go. Yeah, here's another case that's going on that we've been trying to give a little air to, but has been kind of swallowed up in the shadow of the Lindsay Clancy case. Duane Keffe D Davis is on trial for the 30 years in the making murder. That's the wrong way of putting it. The murder that took place 30 years ago of Tupac Shakur. This one is so funny to me because I thought this would be a case that would be something that, I thought the media would really follow this case. Not so much. It's funny to me. I mean, here's a case that was a huge moment culturally when it took place. Tupac was murdered. Oh, my God. And it goes unsolved for so long. And now they've got a person and they're going to try to convict him for the murder. And not to say it's nobody's paying attention. It's just it's not getting the kind of attention I thought it would. Well, one of the ways that they are putting this case together is through Duane Davis's own words, both in interviews that he gave and proffers that he gave to law enforcement, and in a book that he did not author but provided much of the information in that book called Compton Street Legend. I haven't read it. If anybody's read it, let me know. And you're right, Misbehaving. It's hard to imagine another case of a better example of self-snitching than this one. It is really wild. That is, I mean, it's to the point that I do not believe they are filing this case if it wasn't for his own self-snitching. It's a 30-year-old case. It's a circumstantial case. There's no eyewitness coming forward saying, I saw him do it. It's him saying, I was there and I did this, and then other people providing corroborating evidence of it. But it's all him saying he did it. This goes to my theory about people can't keep their mouth shut. I'm going to pull a complete wild U-turn on you guys here, but when I am asked about the Nancy Guthrie case, do I think that will ever be solved? I do. And when they ask, well, how? I go, because people can't keep their mouths shut. People who commit crimes like this, like murders, like abductions, are not smart folks. They can't help themselves. And they have too much to drink, or they get a little too high and they start bragging. It's rare to see them go to the point of giving an interview for a tell-all book, but I just feel like people usually contribute to their own undoing. And that's what happened in this case, and that's what will likely happen in the Nancy Guthrie case. Somewhere, someone who knows something is going to get popped for something. Drug trafficking. And they're going to be looking at 20 years in prison, and they're going to say, whoa, 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 whoa. I've got some information on that lady that disappeared out of Tucson. What will this get me? That's how I think this thing is going to go down, how I think it's going to get broken. And that's, to tie it all together here with the Duane Davis thing, that's how this all came together 30 years later. They knew, by the way, this wasn't your typical cold case where they didn't know. They knew likely he was involved from the get-go. They just didn't have the evidence to put it all together till he provided them with it. So great question. Misbehaving from San Diego, England. I appreciate you asking. All right. Tumwater, thank you so much for supporting the mods with coffees. Appreciate that. Shay, thank you so much for supporting the mods with coffees. Very kind of you. Full-Throated Motion says, if the defense in the Lindsay Clancy case were to get a mistrial with prejudice, would Lindsay Clancy be civilly committed or just out on her own as a free person? Great question. First of all, a mistrial with prejudice is unheard of. I mean, we saw it in the Alex Baldwin case, right? Because the judge felt that there was just such prosecutorial misconduct there that she dismissed the case outright with prejudice. Really incredibly rare. It would not happen in this case, but it does bring up a really good question, Full-Throated Motion, FTM, about what happens to her if this case goes away. Along those same lines, what if it hangs? What if there's a hung jury and a mistrial and people say, will the prosecution pursue this again? I think that they will, but what if they don't? What happens? Nothing. She's a free woman. Even more interestingly, she would not be provided with state-funded health care. She would be on her own. She would not be civilly committed. There would be no jurisdiction over her. She would be on her own to go find help through her normal insurance mechanisms, I imagine. But that's what's interesting about this thing is the only way that they maintain any kind of jurisdiction over her is if she's either convicted or found not guilty by reason of insanity. Great question. Full-Throated Motion. All right. Let's keep it rolling here.
Hi, this is Rochelle in Wisconsin. I have a question, I guess, regarding the Lindsay Clancy case. So if she is moved to the civil court and then determined that she needs to be treated in a medical facility for her mental health issues, it sounds like there's not a time frame from that. It's just when they deem her able to return to society where she's well again. How come some cases someone can be committed to a mental institution for, say, 25 years. We just had a case in the Madison, Wisconsin area where she was committed to 25 years at a mental facility. Like, does that penalty, I guess, versus just the course of treatment for an undetermined amount of time work? Awesome. Thank you.
Rochelle from Wisconsin. I don't know where in Wisconsin. It's a pretty big state. We're going to put you right smack dab in the middle of it. Do you know, Kaylin? Or are you just picking? Okay. Kaylin's saying there's Wisconsin. She found it on a map and she put a dot there. So that's where you are, Rochelle. Can she be committed to a set amount of years in a mental institution? No. The answer is no. You are referencing something I am not aware of, Rochelle. So I did a little bit of digging and I could not find where people have been sentenced to a set amount of years in a mental health institution. Doesn't mean it doesn't exist. I just wasn't able to find it. I have seen situations where people, as a term of probation, were told to get mental health care, but not as a sentence for a conviction. But to bring it back to the Lindsay Clancy case, that's not the way that it would work. The way that it would work is this. If she's convicted of murder, she will be sentenced to likely life without parole. And that's where she will serve her time, is in a prison. And as I said before, she'll receive mental health care and medical health care in the prison. If she is found not guilty by reason of insanity, the criminal courts lose jurisdiction over her. She is then civilly committed. The civil courts then take over. And she goes to a mental health institution, which is a lockdown institution. And there she receives treatment. And what they're looking for there is not a period of time. What they're looking for there is an indication of whether or not she's well. If she returns to stability, mental health stability, if she no longer is a threat to herself or others, and doctors sign off on that, and the court signs off on that, she'll be released. That's the way it works. Now, I'm short-circuiting all of the little steps in between, but that is the way that it works. Now, statistically, most people spend the rest of their life in a mental health institution because they're very, very sick. Because these are people who were so sick they couldn't even appreciate the wrongfulness of their actions. But there are instances where people do recover from that it was some sort of temporary mental illness they were suffering from. I'm not sure how that will work in Lindsay Clancy's case. I think it is interesting that we're speaking about much of this as postpartum related issues. She wasn't a person, as far as my understanding is, that needed mental health care before she was dealing with these postpartum issues. So you have a person who is relatively mentally well. She has her third baby. She starts to suffer from this brain chemistry, hormonal imbalance that just causes her to spiral out of control. But I don't know if that's something that could be addressed. I don't know if she's got underlying larger issues. I know there's been talk about bipolar and undiagnosed other issues, but I don't know. All I do know is that the doctors who should know, if they one day decide that she's fine and she's stabilized and she's no longer a threat to herself or others, they will recommend to the court that she be released. I mean, wrap your heads around that as well. Would we all be feeling like justice was served here if she were out in a few years? I don't know. I mean, it just makes it a far more difficult and complex question. And thank you so much, Rochelle, for asking the question that led us to that conversation. All right. Where are we at here?
Hey, Josh, it's Jimmy McNutty in Torrance, California, watching the Keffe D trial. They're talking about a proffer. Now, let's say they make a proffer to me and I admit I killed somebody, but I said I used a knife. And then it's later determined that I really used a gun. So I lied in my proffer. So what I was listening to this FBI agent say was the proffer is only going to affect the agreement, like my sentence. So since I lied in my proffer, I don't get a deal on my sentence. But here's the kicker. They can't use my admission that I killed him against me, even though I lied. I just lied how I killed him. Is that true, that I could admit I killed somebody, but I lied about the method? I don't get my proffer, but they can't use my admission. Thanks a lot, Josh. We'll talk to you later.
Jimmy from Torrance, California. Thank you so much. Great to hear from you, my friend. And always a very interesting question. So again, getting back to the Keffe D, Duane Keffe D Davis case, now taking place in Las Vegas. A lot of this case has to do with a proffer that he had, where he spoke to police, and that is now, according to the judge, they feel that he waived that agreement, and they're using that statement that he made as one of the statements against him in his current prosecution. But Jimmy wants to know about proffers and how do they work, and when are they considered null and void. And you're right. If you lie during a proffer, it destroys the agreement. Okay. And I have both conducted proffers and sat with defendants who've given proffers. And the thing that I tell them more than anything is you cannot lie here. This is your one opportunity. You have to tell the truth and the whole truth. If you are not prepared to do that, then don't go through with this, because you're going to be giving them a lot of information. And if you are cute and giving half truths, they're going to know. And it's going to blow the whole thing up. Now, Jimmy goes, well, what if I say I killed somebody, but I shot him, and in actuality, I stabbed him? Does that mean that they don't get to use the admission that I killed anybody against me? And the answer is yes, but it's important before you get too carried away with that to understand when proffers are given and when immunity is given. Proffers, for the most part, are to benefit the defendant or the suspect or the person who's testifying during the proffer. Usually, a proffer is a situation where the government's got you. They don't need help getting you. You're not sitting in that chair because they don't know if you've done it. They know you've done it. But you have perhaps information that is helpful for them, for somebody else. That everybody I've ever proffered, I've explained to them, this is the way it works. You can either be the big fish or give the government the bigger fish. But if you don't have anybody upstream of you, then you're in big trouble. So let's take this opportunity to share anything and everything you know. But this isn't a question of they don't have enough on you to get you. Immunity agreements are much more like that. Immunity agreements are much more for the benefit of the prosecution. Because in that case, you want information out of that person, and maybe you can't get that some other way. And so you need to give that person immunity to get them to cooperate. But a proffer is not usually handed out when the target of the investigation is the person they're proffering. It's usually because they want to know, do you have anything that can help yourself out? And we know that the only way that you can offer information to help yourself out is to give you a proffer agreement so that you know you can be forthcoming with us. That's why it was done here with Keffe D too. They knew he was involved. They wanted to know who else could he give up. And he probably played it gangster and didn't give up anybody or lied about what he gave up. But that's kind of a better understanding of what's going on with proffer agreements. Thank you so much, Jimmy from Torrance, for asking that question. All right. Let's keep it rolling here. Big, deep breath. Should we take a big, deep breath midway through? Are you guys having fun? I feel like we're doing pretty good here. We've gone from Kenya to South Africa to Columbus, Ohio, Colorado Springs, San Diego, England. We talked a lot about Lindsay Clancy, but we peppered in some other cases here or there. If you're just now joining us, Nightbot is broken. So like this episode if you haven't already. What else do they got to do? Subscribe if you haven't already. We're so close to a very huge landmark event for this channel. Love for that to happen soon. And you know, I don't know. Thank you so much all for your support for these ad-free lives that we're trying to put together for you guys. Yes, we are having a great time. Good. I'm glad to hear that, rock and roll. Are you juiced? I guess is the better way of putting it. Is everybody juiced this morning? I hope so. There we are. 100% in Cornwall, England. That's all I needed to hear. Everyone is 100% juiced. Okay, good. All right. Well, then I'll get back to our lesson. Where am I at? Here we go. And technical difficulty. Right on cue. Hold on.
Hi, Josh. This is Christy from Orem, Utah. Charlie Kirk was shot about a mile from my house, so it's a case that we have some particular interest in. But I was wondering if you could explain to me why some YouTubers and influencers will use the word assassinated when it comes to Charlie Kirk, and some say murdered or shot, but I heard one say that they wouldn't use the word assassinated because he wasn't assassinated. So I just wondered if you could explain the difference between that, if they're just interchangeable. I appreciate it. Enjoy the rest of your Sunday.
Christy from Orem, Utah. Thank you so much for calling in. Where is Orem? Can we zoom in there? Oh, right by Provo. Is Orem where the university is? I should probably know this. Well, good to hear from you, Christy. Yes, the Charlie Kirk / Tyler Robinson case has taken place right in your backyard. Well, difference between assassination and murder. One, the law is murder. The law, he's charged with murder, so he's not charged with assassination. But I think why you'll hear people referring to it as an assassination. I use the word assassination. I think it is an assassination. Is for the non-legal definition of assassination. Assassination, this is a definition I found. Assassination is the planned murder of a prominent person, such as a political leader or public figure, usually carried out by a sudden or secret attack for political, social, or ideological reasons. And I think this murder falls squarely into that. So I think that's where you hear people using the word assassination. I believe it's an assassination, but from the criminal legal perspective, he's just been charged with murder. I don't even believe that there is an assassination statute. I think what they'll do is sometimes add allegations for when a person is targeted based upon their beliefs, which gets you a little bit closer to the idea of assassination. Interestingly, though, in Utah, they don't have that allegation. So the special allegation, the aggravating factor that they're using in this case is that he put others in direct harm by the way that the murder was committed. In other words, you shoot over a crowd of people, you're likely putting other people in harm's way. Thank you so much, Christy from Orem, Utah, for asking that question. All right. Oh, hold on. I'll say thank you. You can put it back up. Chef Needs. Thank you so much for supporting the mods with coffees. That's very kind of you. Shy Gal says, Josh, do you think that Suge Knight saying he will plead the fifth is really a plea to get immunity? Will that even work? He is an eyewitness. He's like the eyewitness, right? I mean, he's sitting right next to Tupac when the murders took place. He is probably the most important immunity witness, or most important percipient witness in this case. No, I don't think he's trying to get immunity. I don't think his claims for any kind of Fifth Amendment protection hold all that much water either, but I could see where he might argue that. He's gangstering up. He's being a gangster. He's not going to say anything. I prosecuted gang crimes many, many times. Nobody says anything. Nobody says nothing. Even if they're the victims, they don't snitch. It's like the biggest rule is don't snitch. So I can't see him participating in any kind of way. There's no criminal liability that he would want to get himself out from under. And I think he's already serving decades in prison anyways, and they can't do anything about that because that was an unrelated crime. It's just pure gangster. That's what it is. That's why he won't have anything to say. I would love for them to haul him up in front of the court, though, and put him on the stand and make him say it and see if they can't get anything out of him. But I don't even think that'll happen. Great question, though, Shy Gal. And Concrete Jungle says, justice, not vengeance. Improve the system, save others. Lindsay Clancy has extensive proof of mental illness and seeking help many times. Let people plead and prove not guilty by reason of insanity. Yeah, I agree with what you're saying. I think the system does need to be improved. I think there's extensive proof that she did have mental issues and was seeking help. I don't think any of this is about vengeance, but I think it is about justice. And the question for the jury is going to be, is she, in spite of all of this, should she be held criminally responsible? We're talking about 3 dead kids, guys. You can't just say, well, she tried. Well, she tried to get help and she was failed. I mean, that's just not the way it works. It's a far more difficult question than that, but such a great point that you make there. Thank you. All right. Now we're on to our next question.
Hi, Josh, Tiff, Caitlin. It's Little Miss Red Velvet from Manchester. I've not been able to make much of the lives as I've got a big project on, so I thought I'd send a wee voice message. My question is around Suge Knight, who was on the stand. Can the Commonwealth ask her about her beliefs with regards to her religion? And what are the rules and statutes around these kind of questions, like religion and politics? Also, with the sidebars, probably a silly question, but is there any limit to how many? And does the judge decide? And can the judge refuse a sidebar? And lastly, can the judge reprimand counsel for their behaviour towards witnesses or fellow counsel? And is that contempt? Hope you're doing a Sunday Funday. If you are, I'll definitely be there. Bye.
LMRV from Manchester, England. Always great to hear from you. And I love the rapid fire questions. So let's try to get through these as quickly as we can. 1, can the prosecution ask her about religion? The normal answer to that is no. Religion never plays a role. I think that's why the judge got as upset about this as he did, because it was the invocation of some sort of, moral authority here, or religious authority taking place. I think the reason why it wasn't, I think the reason why the prosecution asked it, though I think it was a very miscalculated effort, was, again, it has to do with wrongfulness and the idea of, did Lindsay Clancy appreciate the wrongfulness of her actions? And that might include a religious wrongfulness. Here's the thing, though. Are we really nitpicking whether or not murder was wrong? I don't think anybody's going to argue that Lindsay Clancy doesn't think murder was wrong. I think the argument is, did she know it was wrong when she was committing the murders? Did she know what she was doing was wrong? Not that did she know murder was wrong? So really just bad strategy, did not land, probably offended many people to have asked that question. Is there a limit on how many sidebars? No, there is no limit. Can a judge refuse to take a sidebar? Sure. Many times judges do. Sidebars should be used for the purpose of making arguments that should not be heard by the jury. So instead of dragging the jury in and out of the courtroom to have an argument, you just go to sidebar and have that argument where you're not in the presence or earshot of the jury. You have your little argument and then you come back into court. They're supposed to make things more efficient, but sometimes they become too much, just too many of them. I'm not actually surprised by the amount of sidebars in this case. It's a complex case with a lot of really sensitive issues at play, so I can understand why they would have some. But I've had trials in front of judges where you go, Your Honor, can we approach? Nope. Okay, just deal with it. And then as far as, contempt and the way that the attorneys are treating each other, they're going to have to get a lot more spicy before the judge is going to say, I'm going to find anybody in contempt. Contempt is very rare, and it's usually left for a situation where an attorney is just flat out disobeying a judge. The judge says, quiet down. If the judge says behave and you say, screw that, I'm going to still continue to act however I want, then the judge will find you in contempt. Very rare. But thank you so much, LMRV, for asking the question. Always great to hear from you. All right, where am I off to now, everybody? Any guesses? Any guesses where we're fueling the jet and heading off to?
Hi, Josh. This is Maureen from Monterey. I have a question that I have hesitated to ask because I really haven't quite known how to put it, but I think it's a good question. And so here goes nothing. How much do you think juries can be affected by the demeanor and appearance of the attorneys? Lindsay Clancy's prosecutors are basically unfailingly aggressive in my mind, and they're very stern. And to me, they appear heartless. On top of that, they dress fairly drably and apparently use very little makeup, if any. They don't seem to take that much care with their appearance. Now, I don't think women have to wear makeup, but if the prosecutors used even a little, it might soften their basic appearance and increase their likability. I know I look really ragged without makeup, and it makes a huge difference in my appearance when I do use it, to the point where my iPhone doesn't recognize me when I'm wearing makeup. Do you think the jury could be negatively affected by the combination of their seemingly heartless demeanor and drab appearance? To me, they look more like mean schoolmarms than professional trial attorneys. I don't mean to be kind. This is just my impression. Does law school address how an attorney should dress or present themselves in court? I'm just really curious. Thanks, Joshua.
Maureen from Monterey, California. If you didn't guess Monterey, you're all wrong. We're always good to hear from you, Maureen, and your unending honesty with us. But I loved this question too, because we talked a little bit earlier about a caller who was bothered by Kevin Reddington's behavior in court. And now Maureen is saying, I can barely stand these prosecutors. I think that they seem to be heartless. And on top of that, they need to put on more makeup. The answer to your question is, can jurors be affected by people's appearance and demeanor? 100% they can. Absolutely. Jurors, fun fact, are human beings. Not a lot of people know that. Jurors have the same biases and reactions to things as all of us do. So as much as we are all kind of gossiping and talking about the attorneys and how they're behaving and whether we like it or not, they are thinking the same thing. They're just not talking to each other about it, or at least they shouldn't be. But I guarantee you, when they get back into that deliberation room, they have themselves a little bit of a gossip session about certain things. And this is what's interesting to me, is some people view these two prosecutors and say, I can't believe it. Can't believe the way they dress. I know this one prosecutor seems to be getting a whole bunch of attention online because she's wearing bows in her hair. I will tell you this, do not fool yourself into thinking that the jurors might be feeling the same way about it. Who knows how they're reacting to all of this? They may find these prosecutors to be doing a admirable, valiant job in the pursuit of justice for 3 children that were killed in a horrific way. Or they may be looking at this and going, I find every step of the way for this to be offensive. I have been in the courtroom myself. I've watched the jurors. I can tell you they are very attentive. They do not at all seem exhausted by this, or bored by it. They realize the importance of it. I can just see that on their faces. And I know that at points they have reacted to things that have taken place in court, but don't fall for the second favorite pastime of all trial attorneys, and that's trying to read the minds of jurors. You will rarely find yourself on the right side of that prediction. I remember, and I know I'm running long, Tiffany. Sorry, hun, but I'm still going to tell a story here. I'll never forget. I had a trial when I was a prosecutor, and I give my closing argument. And you try to pay attention to, you're obviously paying attention to the jurors through the whole trial, but especially in closing arguments, you're trying to get a connection and make eye contact with people. And, I remember I would have sometimes jurors nodding, and I'm like, oh, that one's in the bag. And I had this one gentleman who put down his notebook, folded his hands on his chest, wouldn't make eye contact with me, stared straight ahead. And I thought, God, I've lost this guy completely. And when the defense got up, he was like hanging on the person's every word. Now, no real expression on his face, but just my interpretation of the body language was defense has got him and I've lost him. Turns out that guy was my foreperson on a conviction that came back fairly swiftly. Why is that? I don't know. Maybe he felt like he didn't really need to hear anything from me because he felt like he had heard all of it anyways. And maybe he felt like he needed to give the defense one last shot, and that's why he was paying attention. I do not know, but the lesson learned is don't for a second fool yourself into thinking that the way you're thinking about something is exactly the way the jurors are thinking about it. As divided as everybody is on this case, I have to imagine that the jurors are just as divided. Maureen, of course, they are paying attention to. I had a juror talk about my socks one time. I had a juror criticize my socks one time. So they're paying attention to everything, to the way you dress, if you're wearing makeup or not, the bows in your hair, the shoes on your feet. They're paying attention to everything, and especially the way that you conduct yourself. Are you too slick? Are you too sharp? Are you too polished? Are you not polished enough? Are you fumbling over your words? Are you disrespectful? Are you rude? Everything. Great question, Maureen. All right. Michael Garnett, thank you so much for the very kind super chat. Says, I fear that the jurors in the Lindsay Clancy case may not be aware if they rule in her favor, she may be released later on at some point. That would sway my decision if I was on the fence. Kids are sadly lost in this circus, in my opinion. Such a great point, Michael. Jurors are not supposed to consider punishment. They're never supposed to consider that. Now, in some jurisdictions, they're asked that specific question. After they give their verdict, then they decide on the sentencing. Carmelo Anthony, the jurors there in Texas, decided on the sentencing. In other jurisdictions, and in this case in particular, they're not going to decide on the sentence, and they are not supposed to allow that to play a role in their heads. They may be aware of it or not, but it shouldn't play a role because the decision should be based merely upon the instructions, and the instructions don't ask you to consider, hey, by the way, if you find her not guilty by reason of insanity, she'll go away to a hospital and we won't be able to tell how long that will be. That shouldn't play a role, but you're right. I think a lot of people, it may affect how they view this whole thing. Great question, Michael. I appreciate that. And Saving Lives, thank you so much for the super chat. All right. And subscribe to Pandering. Wow. Thank you so much for those memberships. That's very kind of you. Appreciate your support. Really, really very kind. Where are we at here? What am I doing?
Hello, Josh and all the CC fam, mods, and fans. Hope everybody's doing well. I was just wondering about the Lindsay Clancy case. You know, she claims, voices this, that, and the other thing, and the defense claims the doctor's overprescribed, but she's a nurse. She, in my opinion, should know better, I think, maybe. Can that not be evidence? Or no? Wondering how you feel. Hope everybody's doing well. It's Heather from Lancaster, California. Wish you all a wonderful week.
Heather from Lancaster, California, let's put you on the map. I'm glad you brought this up because a lot of people have brought this up about her background as a nurse. What role should that play in all of this? And, you know, I've even heard it to the idea of people say, well, the way that she attempted to take her life, she should have known, you know, the way that she, you know, cut her wrists. It was not a way that a person with medical knowledge would cut their wrists and blah, 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 blah. I've heard that people say, well, wouldn't she know better about how, you know, what kind of treatment she should be getting? My position on this is that that really should not play a role in this, because you're dealing with somebody who, as a nurse, she's not a psychiatrist, right? I don't expect her, just because she's a nurse, to understand how SSRIs and antipsychotics are going to react with each other, and even how she's going to react to them. I think that maybe, you know, I could see in different cases how that might become important. A person's background, you know, a person who's an engineer, you might expect to have a different understanding of mechanics. A person who's a doctor, you might expect to have a different understanding of medicine. A person who's a lawyer, you might expect to have a different understanding of how taxes work, or things like this. I don't know if that plays as much of a role or should be as important in this case, but we'll see how the parties handle it. We'll see how the prosecution handles it. I wouldn't be surprised if they somehow highlight that in some sort of way. I wouldn't even be surprised if the jurors consider it in some sort of way. It hasn't really, in my view, I haven't seen it play so much of a role in this case, but I'm glad that you brought that up, because you're not the first person to have mentioned that. All right, guys. Bust out the hankies. It's that time. We are down to the final 3 questions of the day. Who's going to bring us home today?
Hi, I don't want the message to go on forever, so I want to shout out everybody, give you a quick hello and a quick I love yous. Love what you guys do on a daily basis. I wanted to bring up the case of Chad Doorbell, or Doerman. I can't remember what his name. I should have Googled it. But he's the guy that shot his 3 children, shot the mother in the hand, and then the stepdaughter's the one that ended up calling for help. With all the cases that are going on right now, that seem to revolve around mental health, with the actress that not killed herself, but OD'd, and then the cases that are in court right now, I just thought that, you know, men do the same thing, and I don't know if they get as much attention as the women do with the mental health cases. Anyways, I don't want this to go on for too long. Thank you. I love everybody. I love your show. Continue doing what you're doing. You are one of the best guys out there, and you do have the best listeners. Love yous. Bye. Oh, and hello. My name is Mabel from Canada, Algonquin Highlands.
Mabel from the Algonquin Highlands, Ontario, Canada. Let's put you on the map. Mabel, you have said one thing that I think, as much as we may see this case different ways, one thing we're all going to agree on is that we do have the best chat and the smartest people on YouTube. And you are an excellent demonstration of that. Chad Doerman. This is something I've heard many people, again, reference as, you know, kind of a case involving mental health issues, but where we've changed one of the factors. And here we've changed the sex of the suspect, of the defendant. Chad Doerman, for those of you who are not familiar with the case, back in June of 2023 in Monroe Township, Ohio, shot and killed his 3 boys. Clayton, age 7, again, we're blurring their faces, Hunter, age 4, and Chase, age 3. It is, again, one of these tragedies beyond imagination. Gunned them all down. One of them was trying to run, and he shot him from behind. Nightmare. Horrible. The wife ends up getting shot during that same encounter. He is apprehended, interviewed by police, and speaks, gives a full-fledged confession to everything that took place. And he says that God was testing him. God was testing him and commanding him to sacrifice his children. There was evidence that he was having psychological mental health issues before this as well. He says, one of the quotes that he gave to police was, if God tests you, you have to do it. He says, I was going to hell, let them go to heaven. And why this case is interesting is for a couple of reasons for the discussion that we're having. One, now you are hearing a person who was delusional. I don't know if he was saying that he was hearing voices or just feeling that he was being commanded to do so, but he is also adding a moral value to his compulsions to do something. He's not just saying that God told him to do it, but that God told him to do it because they would go to heaven. And this was, I think, arguably, in his view, the right thing to do. God was commanding him to make this sacrifice. God was telling him he's going to go to hell. They have to go to heaven. You have to do it. This is a test. Now, again, I would argue, okay, did he still understand murder was wrong, though? Right? That would still be the central question at play. But now we're getting into a little bit more of this idea of some sort of moral rationalization for these horrific murders. Well, we don't have an end result to that, because though he did originally plead not guilty by reason of insanity, he withdrew that plea and ended up pleading guilty to the murders in August of 2024 because the state of Ohio agreed to drop the death penalty in exchange for that plea. But it does also ask the question, kind of enter into the conversation too, about what would the reaction to Chad Doerman had been? Would we expect the same kind of support for the mental health struggles that he was going through? I know it's not exactly the same, but it is, I think, enough similarities to raise those questions on, would we expect people to be standing outside of the courtroom? Would we expect the same kind of support that we're seeing online? Again, I'm not trying to say that the people who are supporting Lindsay Clancy are somehow completely in the wrong on all of this, but it does, it's important, I think, for us to explore all of these things as to why this case in particular, whereas other cases with just as horrific circumstances don't seem to have the same kind of cultural moment that the Lindsay Clancy case is having. Thank you, Mabel, for bringing that up. Like I said, a lot of people have referenced this case as well. Another, horrific case. Had he received proper care, would that have happened? I don't know. We don't know enough about it because it never went to trial. But great question. All right. Where are we off to here? Here we go.
Hi, everybody. Hi, Josh. Happy Sunday Funday. So I've been watching the Keffe D trial, Tupac. And my question is listening to Keffe D fail shut-up class, or as Bruce would say, self-snitching, for most of the trial, is that part of the defense's strategy to throw all of his talk out there and say, he said so much, none of this is true? I mean, it was a joke. Is he going to bring up Mickey Mouse and Donald Duck next? I mean, he's bringing up every rap star, everything. Does any of this even make sense? What do you think? Thank you.
Sonia from Chicago, Illinois. Always a pleasure to hear from you, Sonia. Again, talking about the Keffe D trial, the murder of Tupac. This is a great point. This is a weird case because usually the prosecution, if there are statements being made by the defendant, they are self-serving and the prosecution is saying, don't believe a word that comes out of that person's mouth. And the defense is saying the defendant is being honest with you. The roles are completely reversed in this case. The prosecution is saying, believe everything this man has ever told you. The books that he's written, the interviews that he's given, all of this is true. He was involved. The defense is saying he's full of crap. He's just a big talker. Look at all the stuff that he talked about, all the things that he exaggerated, all of the people he said he met, all of the big, tall tales that he was telling. You can't believe a word coming out of this guy's mouth. I'll be honest with you. It's a very clever defense because he was telling a lot of stories. He was giving a lot of, aside from his involvement in the murders, my understanding is that book is just kind of full of a bunch of exaggerations and tall tales. And they're saying, listen, the whole thing was designed to just sell books. The guy's a big talker. He was trying to make himself relevant. And he was trying to get a buck. That you can't convict a man for that. Very interesting strategy in this case. We'll see how it all plays out, obviously, with jurors. For Keffe D's sake, though, I feel like it's not just the book. If it were just the book, he might have a fighting chance, but it was a lot in addition to the book for the reason he's sitting in that defense chair today. All right. Last question, everybody. Who's bringing us home today?
What's up, y'all? Court Dog Daniel here. Josh, it was great chilling with you outside the Lindsay Clancy trial for a minute. And I tell all my friends that you're my legal hero. So anyway, Josh, can you do something that would be really cool for all of us? I've developed a series called Play a Juror in the Lindsay Clancy trial where I take issues that a jury might actually have to wrestle with when deciding a case. So Josh, bear with me. I want you to take off your brilliant legal hat right now and pretend that you've been called for jury duty. Now, I know that's probably not happening since you're in the business, but let's just pretend. Okay, so I'm going to give you my episode 9 question, and I would be honored and excited if you would answer it as Josh Ritter, the juror, not Josh Ritter, the lawyer. So here's the question. If a judge told you to completely disregard something you just heard, would you really be able to erase it from your mind, or being told not to consider it actually make you remember it even more when you were deciding the case? 87 days till crime, Cruise. Juice!
CDD from New Britain, Connecticut, but now temporarily residing in Plymouth, Massachusetts. Great question, my friend. One of my dudes, great question. If taking off my lawyer hat, happy to do it. If the judge told me to completely disregard something I just heard in court, would I be able to do it? And my answer is no way. No way would I be able to erase that moment from my mind. Now, would I do my best to try to not allow it to play a role in my deliberations? I would try. I guess it really would depend on how outrageous that piece of information was that we were being asked to disregard. The reason we do this, though, obviously, is we can't be declaring mistrials every time something slips in court. You got to keep moving stuff down the line, right? You can't gunk up the works and every time something gets blurted out in court, end everything and start all over again. So you can understand why judges go, disregard that, move on, strike that question, move on. I'm instructing the jury to disregard it. But I think we ask a lot of jurors. We ask them to ignore a lot, to disregard a lot. You know, there's a reason that the phrase is used often that you can't unring the bell. And I've had situations where I thought that bell cannot be unrung. And judges usually say, I've instructed the jury and I'm not going to do anything more. And unfortunately, many times too, on the appellate level, that's the way they'll view it. They'll go, well, the jury was instructed and there's no indication that they inappropriately considered that evidence. Great question, though, my friend. Court Dog Daniel. All right, don't go anywhere. Quick announcements get you guys out of here. First of all, let me thank the Crafty RN. She says, hit that like button, and we hope that you all do that. Gossip and Rumor is here. Thank you so much for all the hearts. Appreciate you. Good to hear from you. All right. First of all, thecourtroomconfidential.com. If you enjoyed the questions from today, but you thought, you know what, they didn't get to the thing I wanted to ask, you can leave a message yourself. Go to thecourtroomconfidential.com and click on send us a message, and I will do my best to answer your question at the next Sunday Funday. Memberships. Thank you so much to everybody who gifted a membership. Another big shout out to Eroy for the 20 gifted memberships. Very kind of you. If you didn't receive one, do like Saving Lives did and go to thecourtroomconfidential.com and become a member yourself by clicking on Become a Member. Do like Debbie Gregson just did and become a member on your own by going to thecourtroomconfidential.com and clicking on Becoming a Member. And then finally, merch. If you guys need to pick up yourself a new t-shirt, or you need a new beach towel, or you need some flip-flops, or you need a tote bag, we've got you covered with our summer merch drop from thecourtroomconfidential.com. Just click on the shop and go ahead. Pajama pants, flip-flops, t-shirts, more t-shirts, tote bags and koozies. What else do we got? We've got you covered. Slides, Tiffany's new permanent footwear. We've got you covered at thecourtroomconfidential.com. Thank you to Best Nancy for gifting a membership. Alibis Melting the Heat and the Not My Fault bumper sticker. All right. Stay tuned. Here's what we got coming up this week. First of all, over on our sister channel, Courtroom Confidential Live Trials, where many of you have been watching this case, we've got two things going on. One, we've got day 6 of the Duane Keffe D. Davis trial. So please check that out. Oh, thank you. Thanks, Tiffany and crew, for that. And day 19 of the Lindsay Clancy trial. We've had a very healthy and robust group of people watching that with us, and we encourage you all to do that. That's on our sister channel, Courtroom Confidential Live Trials. Monday, tomorrow, we're back here again, live at 5 p.m. Pacific, 8 p.m. Eastern for more discussion on the Lindsay Clancy trial and whatever else is going on. Wednesday, same thing, same time, 5 p.m. Pacific, 8 p.m. Eastern. Guests to be determined. Let me give a very special shout out and thank you to our mods, because they have been working overtime on this Lindsay Clancy case. It is, I imagine, exhausting, and we couldn't be doing it without you. So everybody, please give a big shout out and round of applause to Afton, Sonia, Kathy, Therapist Best Nancy, and Becky B for holding down the fort. Before I let you go, I don't want you to send you out into that cold world on a Sunday without something else to watch. So turn right back around and you can watch our weekly roundup here on the channel. This episode came out yesterday where we sat down with lawyer Lee, had a really great conversation with her. We're talking about the Lindsay Clancy case. We also gave you some updates on Tyler Robinson, Carmelo Anthony, Laken Snelling. So please check it out. It's up on our channel now. And then something very special I was a part of. I want to show you a sneak preview. No, it's not a sneak preview. It's already out. So here's a trailer from a documentary that we did on Fox Nation about the Lindsay Clancy case called Behind Closed Doors, the Lindsay Clancy case. Check it out. January 24th, 2023, the 3 Clancy children were murdered in this small Massachusetts community. Their mother, Lindsay Clancy, admitted to the murders, strangling them with exercise bands before she attempted to kill herself but failed.
what is undeniable here is just how horrific the case is.
This is a deeply tragic case on all levels.
There are so many differing opinions. There's so much evidence cutting both ways.
We are watching a mother in absolute pain in a courtroom every day. And I think there's more women out there who can empathize with that than people realize.
Very proud of that. We put a lot of work into it, and it gives you a really good timeline of the events leading up to the murders. Well worth watching. Please check it out right now. It's on Fox Nation, Behind Closed Doors, the Lindsay Clancy case. All right, everybody. You're all fantastic. You are now released from class and able to go about your Sunday. Kaylin, you're fantastic. Thank you for everything that you do. And Tiffany, you are, as always, the best thing that ever happened to me. Take care, everybody. We will see you here tomorrow night. Bye.